jibber jab, bamboozle, nooka noozle, bippity bop, she called. You jibber jab, bamboozle, nooka noozle, bippity bop, she called. I mean, you keep on talking, but you don't know where to turn.
Welcome, I'm John Caldera, president of the Independence Institute. You're watching Independent Thinking. Well, you always thought your property was at risk. Maybe a little eminent domain could take your home after the Kelo case. It could be turned into something else, like a hotel. But did you know that a government outside your city could take your property? To talk to us about that from the Independence Institute, who heads our Property Rights Project, Jessica Corry. Glad to have you here.
Thank you so much. Good to be here.
And the Supreme Court overruled this man's law, so we thought we better have him on. Senator Shawn Mitchell and lawyer extraordinaire. Glad to have you.
John, good to be here.
All right, let's kind of work backwards here. We've got a case where the Colorado Supreme Court, on an overwhelming ruling, 6-1, said it's all right for Telluride to condemn land that's not in Telluride. Let's go over here first. Give me the basics first, and let me see if I understand the lawsuit. What did Telluride do?
Well, Telluride attempted to condemn property outside its territorial boundaries, so outside the town limits. And the property was owned by a man named Neil Blue. He was a very easy man to vilify. This was a San Diego-based defense contractor, multimillionaire, really had a man who had lived the American dream, very, very wealthy. He's an older man. And he had attempted back in the 80s to put a series, I think it was about 28,000 square foot homes on this property. Now, these homes would have been very spread out still on 500 or 600 acres, but the town didn't like that, and they spent the next 2 decades attempting to condemn his property.
Why did they want his property? I mean, it's his. What was the goal?
Well, the Telluride Valley is a beautiful and unique setting. It's a narrow valley. Telluride is nestled up in the sort of the crux of the horseshoe, and the valley is a beautiful open space that Telluride just didn't want developed. They said, we like the view, we like nature, we like birds and bees and trees, and we don't want anyone to build anything there, and they wanted to stop them.
Well, that's a nice thing. I live in Boulder, and one of the rare things I think Boulder did right a long time ago was it bought open space outside of its city, and it had a green belt that is now open space that Boulder can enjoy. So why didn't they just buy this land?
Well, in 2006, Neil Blue, after fighting this battle for 2 decades about what was going to happen to this land, consented to a compromise, and would have left 90% of the property preserved, and he would have built just on the remaining 10%. So you would have gotten a lot of that scenic preservation, but still allowed him to build on that remaining property.
Right, so let me see if I just understand the basics here. The city of Telluride doesn't own this land, but you have to go through this land to get to Telluride.
It not only doesn't own the land, it's not part of the city. This land is outside of city boundaries, right, so in unincorporated San Miguel County.
All right, so it's not even in Telluride, but you have to drive through it in order to get to Telluride. Right. And it's pretty, it's very beautiful. And so instead of buying the land, they decided to condemn it, that is, to take it by force, give them whatever modern compensation there is for it. Can cities, any government in Colorado, condemn land right now, before this went through the Supreme Court, outside of its boundaries?
They did have a constitutional authority to condemn land outside of city boundaries for specific purposes. The Constitution says that cities can condemn land for things like easements and right-of-ways and sewage ways and power projects, basically a necessity policy. If this is important for the physical functioning of your city, then you can acquire the property to make it work.
So you need a pipeline to bring in water to your city. You can condemn the right-of-way to build the pipeline through that land.
Exactly.
But was there anything that said you can condemn this land because, well, it's pretty and your city wants to have it?
No, there was nothing like that, and that was the fight when this case got to the Supreme Court. Actually, there's a little bit of backstory. So while Telluride wanted and was in court trying to condemn this property, I was coincidentally sponsoring a bill in the legislature at the same time to limit government's power of eminent domain for private economic development. Take property from mom and pop and give it to a mall developer or something.
Take the donut shop that's family-owned and give it to Walmart for a megastore.
Exactly. That bill was working through the legislature, and the Telluride Corporation saw it and realized that it would fit an amendment that might address this other abuse of eminent domain power. So they lobbied and helped promote an amendment that said cities cannot condemn It basically clarified what's already in the Constitution that says cities can condemn for these necessary functions.
Explain that to me in real simple ways. The Constitution says a city can condemn, obviously, inside its own property, inside its own city boundaries, but it can also condemn outside its city boundaries for those narrow purposes. Do I have that right?
That's right.
Open space is not one of those purposes, right?
However wonderful and desirable it is, it's not essential for a town's functioning and survival. And that was the argument that the Telluride Corporation made. The legislature accepted it, passed with a bipartisan majority, said, yeah, governments shouldn't be able to just grab their neighbor's land because they think it looks pretty. The legislature passed that overwhelmingly.
So not only did the Supreme Court in this Telluride case say that your bill with that provision that was added to it is off, but does it change the Constitution? Does it now put in open space right in there with all utilities and power lines and sewer lines and land that just happens to be really pretty and we don't want to buy it at face value?
Well, the court would tell you no, they're not changing the Constitution. They're just honoring the long-established principle that cities have this power to condemn property for good things and for useful purposes. But this is the most aggressive, expansive thing that a city has ever tried to do and that the court has let it get away with. The court pretended that it was just in the same chain of cases along with sewers and water pipes, but really it just declared open season on people's private property.
Is this only in Telluride that this problem is happening?
It's happening everywhere. And what the court said is that cities can condemn for any lawful or municipal purpose. So in this case, we had somebody we could easily vilify, a landowner who's worth millions and millions, maybe billions of dollars. He was a defense contractor, like I said, so obviously in Peacenik, Telluride, or other hoity-toity resort communities, he's not going to be a popular guy. But we are seeing that this decision, even before it got to the Supreme Court, an appeals court decision, had already emboldened municipalities across the state to start taking land outside of their boundaries for purposes of open space.
Like
We've
where?
got a case right now in Parker where a family-owned business is facing the threat of losing 80 acres by the town of Parker, even though they're outside of those territorial limits of Parker.
So they're not in Parker, but Parker's going to take their land.
That's right. And we had a case in Golden just a couple years ago where Golden tried to condemn part of the Jefferson County backdrop, at the front of the Front Range, where, of course, many people are aware of the effort it was a successful effort to combine 4 towers to build a new HG tower.
These are the antennas we see on
that's correct.
Outside
Lookout
of school
Mountain.
mines. There's a wonderful mountain. It's got all sorts of antennas on it, and they wanted to put on one for HDTV, but the city of Golden tried to condemn that land in order to keep the tower off.
That's right. Even
but it's
though
not in Golden.
Exactly. And I think what we're going to see with this decision is cases that are much more complicated, where you have much more sympathetic landowners. Now there is nothing to stop Denver from condemning in unincorporated Adams County or Jefferson County, or Boulder could start condemning outside of its territorial limits. So I think this decision can be promoted. The 6-1 decision, you can say, is really a pro-home rule decision, but it's going to cause a legislative mess, and we're also going to see a lot of litigation. And unfortunately, we're not going to see cases where the landowners are too poor to fight the legal battles like the one Neil Blue did here with Telluride.
Let's take on the 6-1 bit, which really surprised me. I understand that Colorado Supreme Court is very left-leaning, and it shows that often, but 6-1, is there some sort of angle to this that I'm missing? Is my desire to protect property rights, am I so blind to that I'm missing some very strong legal element here that just hasn't been made clear to me?
Well, I don't mean to get into the legal weeds here, John, but the decision was almost 5-2. We had a 5-member majority opinion, a concurring opinion by Justice Coates, who said, yeah, I'm with the majority, but here are some limitations and cautions, and then the dissenting opinion by Justice Ide. What Justice Coates said is the majority recognizes that the Constitution allows cities to condemn property this way, and if it's a constitutional power that the state constitution gives cities, the legislature can't tinker with it by mere statute. Justice Coates said, okay, the legislature can't take that power away, but it can reasonably regulate it. It can channel it, it can guide it in certain ways, and with that understanding, I'm with the majority. Justice Ide said, no, Justice Coates, there's no such restraint or limitation or qualification on the majority opinion. This basically says cities, you can do whatever you want. If it's an appealing public purpose and you want to condemn property, you're allowed to do it. Politically, here's one of the things that's so